The first case to be presented today is the case of Goh Teng Hu and another against Ample Objectives Sendirian Berhad, 2021 3 MLJ 159. The facts for this case is Goh Teng Hu and another party appeal adverse ruling from the High Court and the Court of Appeal in a federal court case against Ample Objectives Sendirian Berhad. As fourth and fifth defendants, an issue arose from a writ filed on August 11, 2016. The attempt to serve the writ on August 22, 2016 via AR registered post had procedural flaws. The affidavit lacked AR cards, providing only proof of posting. This led to a judgment in default of appearance, JIDA, as the appellants failed to enter an appearance. Efforts to set aside the JIDA were dismissed by the High Court and Court of Appeal, prompting the current appeal. The appellants argue for reconsideration, citing procedural errors that denied them from a fair chance to present their case. The issue in this case is whether the validity of the writ service through AR registered post, the absence of AR cards in the affidavit of service, the entry of JIDA against the appellants, the High Court's dismissal of the application to set aside the JIDA, and the consistency of decisions in the appellant's appeal indicative of potential issues in compliance with procedural rules, fairness, and legal reasoning.
Today I'll be talking about the supporting provisions and cases. We start off with Order 10, Rule 1 of the Rules of Courts 2012, and also Order 62, Rules 9, and Order 13, Rule 7. This explains a lot about the writ of service, and also in the form of Form 12. This plaintiff should represent writ endorsed by defendant solicitor, accompanied by a stated statement indicating the solicitor's acceptance in service of the defendant. On to Section 12 of the Interpretation Acts 1948 and 1967. Definitely it's a written law authorized or requires a document to be served by post. Until then, its contrary should be proved. This can be seen in the case of Wilkinson and perhaps CHUAH Bank Hawk, which will be explained later on. Not only that, in the case of Chong Wei Meng and also Yap Keh Huat, the Court of Appeal ruled that establishing a return of acknowledgement with the registered post is not mandatory and recommend. Of course, in these cases, the acknowledgement is written by post of office serves as an additional evidence. So, with that, we can see in the analyzed part.
Good day, Doctor. I'm Hokaman metric number 279215. Now, I will explain regarding the analysis part. According to Order 10 of the Rules of Court 2012, a writ shall be served personally on each defendant or sent to each defendant via prepaid AR registered post to his latest known address. The first attempt of the service should, as far as possible, be made within 1 month from the date the writ is issued. There are two ways permitted by the statute, which are personal service and AR registered post. If the latter approach is selected, then the writ must be served within 1 month from the date of issuance. Moving on, a duly served writ must accompany with the proof of service of the writ. According to Order 13, Rule 7, Clause 1b, the proof of a duly served writ that can be used to enter a defendant is an affidavit filed by or on behalf of the plaintiff proving due service of the writ on the defendant, or the plaintiff produces the writ endorsed by the defendant's solicitor with a statement that he accepts service of the writ on behalf of the defendant. To sum up, the writ can be served by AR registered post, and to enter a judgment in default, an affidavit must be filed to prove that the due service of the writ on the defendant, and also the writ endorsed by the defendant's solicitor with a statement that the solicitor has accepted the writ. Okay, so what constitutes due service of the writ on the defendant? It must be read as the service in effect. In other words, the writ was received by the defendant. The writ that was posted by the defendant cannot logically show that the defendant has received the writ. In this regard, the plaintiff or the respondent in this case rely on Section 12 of the Interpretations Act, which stipulates the presumption of the service have been effected and it was conclusive proof of service. By looking at the Section 12 of the Interpretations Act, service shall be presumed until the contrary is proved and shall be presumed to have been effected at the time when the letter would have been delivered in the ordinary course of this post. The court also properly pointed out this section is a double presumption provision which presumes the service and time of service. In this case, the court had found that the presumptions are rebuttable by proving to the contrary, as the wording used in this section, until the contrary is proved, overruled that the High Court and Courts of Appeal's decision that the posting of the writ by AR registered post was conclusive proof of service. Therefore, in the end, the facts that were used to rebut the presumptions under Section 12 of the Interpretations Act are admitted by the court. For the first appellant, firstly, the writ was received by the brother of the appellant instead of the appellant himself. Secondly, the appellant was not residing at the address of the service at the material time. And thirdly, the brother who received the writ and signed the AR card did not inform the first appellant. While for the second appellant, the AR card served to the second appellant was never returned at the material time. These facts were corroborated by the respondent's failure to produce an AR card signed by the first and second appellant. To top up, the requirement to send the writ by AR registered post addressed to the last known addresses of the defendants or appellant in Order 10, Rule 1 has not complied. Therefore, the presumptions were rebutted on the balance of probabilities. Apart from that, it must be noted that Section 12 of the Interpretations Act is rebuttable, which also means that there is no conclusive proof of service by merely invoking Section 12 of this Act. The party who denies is allowed to introduce facts to prove to the contrary. The court also explained that Section 12 of the Interpretations Act kicks in when the writ is sent to the defendant's last known address to prove the service has been affected. However, it is rebuttable by the defendant by showing the court that he is not residing at the address, hence the AR card was not written. As the presumption of service are rebutted, the issue was then became whether the AR card must be produced as proof of service before the judgment in default could be entered against the defendant or appellant. If it is not mandatory, the judgment in default could be entered against the defendant. In fact, the respondent relied on 2 cases to support that proof of sending by prepaid AR registered post is sufficient. In the case of Yap Kehuat against Pembangunan Warisan Murni Sejahtera, the Court of Appeal held that there is no necessity to prove that the acknowledgement of the AR registered posting has been written. If it is written by the post office, then it is further proof that it was not only sent but also received. Yet, for the purpose of service, proof of sending by prepaid AR registered post is sufficient. Yap Kehuat's case was then followed by another Court of Appeal case, which is Sivamuti against Lembaga KWSP and the case of Pengkalan Concrete against CHUAH. In fact, under Order 10, Rule 1, Subsection 1, nothing is indicated that the plaintiff must evidentially prove that the named person in the writ must be the person who had received it. In this case, all the prerequisites were fulfilled. In fact, whether that the writ had physically arrived or had been received at the last known address, it is normally confirmed by the direct evidence. These 3 cases were not rebutted by the judge as the judge did for other cases that the respondent cited. The court also considered the cases relied on by the appellant, which is the case of Chong Wai Meng against Pembangunan Nasional Berhad, where the court ruled in favor of the appellant, saying that the AR card is a prerequisite before judgment in default can be entered against the defendant. It can be observed that the decision delivered by the Court of Appeal in the case of Yap Kehuat relied by the respondent, while the case of Chong Wai Meng relied by the appellant. At this time, the Federal Court was obliged to solve the discrepancy in this matter. The Federal Court has accepted the argument that the production of AR card can prove that the defendant had acknowledged receipt of the writ by signing on the AR card. This is the reason why Chong Wai Meng case is to be preferred over Yap Kehuat case. The learned Federal Court judges rule that it is injustice and unfair to allow judgment in default application when the defendant or appellant who have no knowledge of the action are attached with a liability. The appellant should be given a chance to explain why the judgment in default should not be entered against them. The purpose of Order 13 Rule 7 of the Rules of Court 2012 is to ensure that the action has been brought to the knowledge of the defendant before the court to seal the judgment in default. The court also further opined that the service of AR registered post is allowed by law, and the court should exercise the caution before entering judgment in default to avoid causing any hardship to unsuspecting defendant. Due to justice, the AR card must be produced as proof of service before the judgment in default could be entered against the defendant. With all due respect to the learned Federal Court judges, it is asserted that the judgment in this case is correct, wise, and reasonable. In the case of Wilkin Sdn Berhad against Chua Beng Hock, it has a similar decision as appealed in the instant appeal. The decision that the AR card must be signed or acknowledged by the defendant personally and returned to the sender is upheld, and the discrepancy in previous decision is resolved by the Federal Court. When the plaintiff wants to enter judgment in default against the defendant must have the knowledge that the judgment in default is going to be entered. Otherwise, it's a deprivation of the defendant's right to explain to the court why the judgment should not be entered.
So the conclusion for this case is ensuring fairness in legal procedures requires precise writ service following Order 10, whether through personal service or AR registered post within 1 month. Deviations result in unsuccessful JIDA applications. For AR registered post, the writ must reach the last known address with signed AR cards, crucial for evidence. The Federal Court prioritized practical justice, preventing judgments without the defendant's awareness. Adhering to procedures is vital to prevent injustice. The plaintiff must produce an AR card for JIDA. In the case, the Goh Teng Hu precedent ensures defense against claims without rights deprivation in recent High Court cases. The second one is the case of Tuan Haji Ahmed Abdul Rahman against Arab Malaysian Finance Berhad 1996 1 MLJ 30. In this case, Arab Malaysian Finance Berhad secured a default judgment against the appellant on July 8, 1988, demanding payment of approximately 4 million plus 1% interest. The appellant challenged, citing a violation of court rules. The senior assistant registrar set aside the judgment, prompting an appeal by the respondent. During the appeal, appellant argued ambiguity in the default judgment amount. The trial judge ruled in favor of the respondent, stating it didn't qualify as a charge action. Additionally, submissions by the appellant were disregarded and the judge considered the default judgment's defect fixable through the loan agreement. The judge criticized the appellant for delay, likening the case to a consent judgment and suggested adherence to specific terms. Instead of setting aside, the judge opted for amending the judgment. Dissatisfied, the appellant pursued another appeal. The issue in this case is whether the appellant's claim of irregularly obtaining the default judgment, allegedly in violation of Order 83 Rule 4.1 of the Rules of the High Court 1980, raises concerns about the clarity of the judgment, the nature of the respondent's legal action, the appropriateness of declining additional submissions made by the appellant, the curability of the judgment's defect through the loan agreement, the impact of an alleged delay in filing the application to set aside, the comparison to a consent judgment, and the judge's decision to amend rather than set aside the judgment.
For this case, among the provisions and cases cited include Order 2 Rule 2.1 Rules of Court 2012, which states that an application to set aside any judgment for non-compliance with these rules shall not be allowed unless the application is made within reasonable time and before the party applying has taken fresh steps after becoming aware of this irregularity. The court relied on this provision due to the appellant making an application to set aside the default judgment against him. The case also refers to Order 83 Rule 4.1 of the Rules of Court 2012, which states that in a charge action begun by judgment in default, it shall not be entered except with leave of court. The court ruled that this provision, however, was not relevant, as the application was not concerning a charge action. In arguing the validity of the default judgment on the basis of uncertainty, the judge had erred in finding that the new contention could not be brought as it was never brought before the registrar. The court relied on the case of Blundell v. Rimmer, in which Justice Payne said that clear on authority that appeal from district registrar is a rehearing of application, and I am entitled to treat the matter as though it had come before me for the first time. The court further cited the case of Armitage v. Parsons. In this case, the plaintiff had obtained judgment in default of appearance, and as a result of an error, the judgment included a sum by way of cost which exceeded a few shillings. An application by the defendant to set aside the judgment on grounds of irregularity was dismissed, in which the court held that clerical mistakes in judgments may at any time be corrected by the court or the judge on motion or summons without any appeal. Furthermore, in answering the issue of delay in application by the appellant, the court relied on the case of Bell against McGregor. In this case, it was also an inherent jurisdiction of the court in preventing an abuse of its proceedings, in which they had power to set aside the judgment in default despite the defendant's application being out of time. The court also relied on Order 42 Rule 13 of Rule of Court 2012, in which it states that save as otherwise provided in these rules, where provisions are made for the setting aside or varying any judgment, a party intending to set aside or vary such judgment shall make an application to court and serve it on the party who has obtained the judgment within 30 days after the receipt of the judgment by him.
By applying this case, the judge was precise and correct in setting aside the judgment in default as it was deemed raised uncertainty and irregularity obtained which does not comply with the Order 83 Rule 4 Clause 1 of the ROC 2012. By following the case of Blundell against Rimmer, it implied that an appeal for the registrar to the High Court judge is regarded as a new hearing at which new argument may be raised. This would have meant that the judge in our case should have heard the appellant's argument. According to the order above, a plaintiff who filed a charge action by rape may not enter a judgment in default of prison without the court provisions. The defendant only need to bring out the matter of irregularity. In the case of South East, as a special asset management brand, Egalajan Manan, son of Sinakano, the defendant has appearance resulted in the issuance of the sale order. The defendant then raised an objection arguing that the sale order was not included with the prescribed procedure, since the plaintiff should have obtained permission from the court as per order in Order 83 Rule 4 of the ROC 2012. The High Court ruled in favor of the plaintiff based on the applications of the Order 83 Rule 4. The implementation of Order 83 Rule 4 Clause 1 is subject to particular requirements. Firstly, the action must be initiated as charged, and secondly, it must be initiated through the use of freight. Under this regulation, the plaintiff must request permission in order to obtain a default judgment. The request must be accompanied by a notice of application which must be sent to the defendant. Our case does not meet the criteria outlined in the Order 83 Rule 4 Clause 1. The respondent cause of action includes seeking restitution of the fund for the appellants without any associated fees. Hence, the respondent does not need to seek permission from the court prior to the obtaining default judgment. Moving on, there are two possibilities causing if the defendant failed to appear within the specified time range. First, the defendant appeared after the time frame provided in Order 12 Rule 4, but before the judgment was issued. According to the Order 12 Rule 5 Clause 1 of the ROC 2012, the defendant is not permitted to enter an appearance of judgment has been rendered without leave of court. In the second instance, the defendant made an appearance after the specific period and subsequent to the judgment be rendered. If the defendant failed to enter an appearance within the specific period, the plaintiff have the right to request a default judgment against the defendant. Order 13 Rule 1 of Clause 1 of the ROC stipulate the provisions for liquidated demand which are applicable to our case. The quantity must be determined or able to be determined using other methods and must not be evaluated as damages by the court. Additionally, the court possesses an inherent jurisdiction to prevent an abuse of its proceeding, as in case of Bill against McGregor, which they have the authority to vacate a judgment in default even if the defendant filed an application after the specified time has passed. So in our case, the appellant submitted his deal to nullify the default judgment in 3 years later. Therefore, it is categorized as the second instance in which the appellant did not act within the specific time frame and after the judgment was rendered. The respondent was entitled to obtain default judgment under the Order 13 Rule 1 Clause 1 of the ROC 2012 for a specific amount owed. The presence of the interest rate did not prevent the respondent from doing so. Moreover, the court have extensive authority to set aside or alter a default judgment as granted by Order 13 Rule 8 of the ROC 2012. There are two primary reasons for the court to set aside a default ruling regarding its validity. Initially, the default judgment is irregular. Nevertheless, the defendant possesses a valid argument in his defense. In the case of in Armitage against person, the appellant had obtained judgment in default of appearance, as the judgment contained cost of amount exceeding a few shillings to due an error. A motion by the defendant to vacate the judgment on the ground of irregularity was denied by the court, which ruled that clerical errors in judgment may be rectified without any appeal at any moment. The ground to set aside a default judgment is irregularity. According to the Order to Rule 1 of the ROC 2012, the court have the authority to amend the irregularities instead of setting it aside. This authority is contingent upon the considerations of fairness and justice. For instance, in our cases, the presiding judge removed the phrase daily rest specific from the ruling, although this action did not rectify the flaw. Despite the delay in filing the application, Malaysian court had frequently exercised their inherent discretion to vacate a default judgment. With regard to the 3-year delay in our cases, the court judgment specified that it possessed the authority to vacate the judgment despite the extended duration, on the condition that no party has been hanged as a result of the delay, or the default judgment were irregular in their nature. The Federal Court ruled in our case that a concerned judgment should not be equated with default judgment.
By applying the case of Sweet Government and Company Limited against New Pet Limited, state that the consent of both parties is essential.
On the contrary, in our case, the default judgment was rendered in the High Court of Kuala Lumpur without the appellant present. The judgment was reached with the effort of mediation, negotiation, or compromise in order to obtain the consent of both parties. Therefore, the trial judge erred when he stated that the two judgments were similar in nature. In summary, we concur that the ruling rendered by the Federal Court was prudent and precise. It was imperative that it set aside to prevent the appellant from being subjected to procedural injustice.
In summary, a plaintiff can pursue a default judgment if the defendant fails to respond within the specified time frame. The defendant cannot enter appearance without court permission. To annul a default judgment, the defendant must submit an application and affidavit within 30 days. The court assesses if the judgment was irregular with the power to set it aside or amend for justice. It also scrutinizes the merit of the defendant's defense, requiring evidence of a triable issue. If the application exceeds 30 days, the court considers the reason for the delay, requiring a bona fide defense without intentional prejudice. Strict adherence to civil procedure rules and timely actions are essential for effective dispute resolution. Understanding these procedural intricacies is crucial for all parties involved in civil litigation.